Call for is not received. Issue reminder, list the matter. Issue reminder to positively forward the CD on 1st September.
Oblige. Please, Your Lordship.
CD?
No, it's
LCL scan copy.
All right.
Also, this is regarding ground of arrest, no?
Grounds of arrest.
So
And
also
Lordship-
now, what am I going to do?
Lordship, as on today, 494 behind our Lordship.
494 days.
494 days, Lordship.
It will be a 1 year. How many months?
1 year, Lordship. I have not calculated, Lordship, 1
Maybe
year.
2 year, 2 months. 1 year, 2 months maybe.
Most probably
Hmm.
3 months, Lordship.
Hmm.
Lordship, in page number 39 and 40, Lordship, the notice, Lordship. In which notice only the PS case number and the section, Lordship, of NDPS Act has been mentioned. And no grounds of arrest is there, Lordship.
Okay.
Nothing is there, Lordship. And in page number 40, under section 50A, CRPC notice, there is also same. Nothing is there, Lordship.
Okay. What is the contraband?
Contraband is, Lordship, 720 Preven plus capsule, Lordship, and 119 Roscoe cough syrup, which is codeine phosphate, Lordship.
720 spas.
Preven plus capsule.
Spas plus capsule. And how much? What? Cough syrup, how much?
Cough syrup 119
119 bottles of.
bottles of 100 ml.
Okay. Yes, PP.
Also, one judgment has come, Lordship. Recent judgment, Lordship, and that is Lordship. 2025 SCC online SC 1702.
2025.
SCC online SC 1702. This is State of Karnataka versus Sri Darshan ETC.
ETC meaning many others.
No,
Or
ETC is there only.
State of Karnataka versus
ETC,
Karna
etc. is not there. It is capital E.
versus Darshan ETC. Okay.
So, here in this also will find also in para 20. In this, so many facts has been discussed in this case. So regarding law incarceration, regarding how what has to be looked into regarding whether there should not be a mini trial during the for allowing bail. All the evidences should not be appreciated. Do not court do not go to into the for appreciation of the evidences that has not to that should not be go into. All these are along with that also that courts are not expected to render findings on merits also. Therefore, delay in furnishing the ground of arrest cannot by itself constitute a valid ground for grant of bail. Here, Article 22(1) has been discussed. Mehan Kumar Pravir Burkasta is also discussed. I'm going to read that also. 20.1.1. The learned counsel for the respondents accused contended that the arrest was illegal as the ground of arrest were not furnished immediately in writing, thereby violating Article 22(1) of the Constitution and Section 50 CRPC, now Section 47 of BNS. The submission, however, is devoid of merit. 20.1.2. Article 22(1) of the Constitution mandates that no person who is arrested shall be detained in custody without being informed as soon as may be of the ground of arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Similarly, Section 51 CRPC requires that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. Article 1.3. the constitutional and statutory framework thus mandates that the arrested person must be informed of ground of arrest, but neither provision prescribes a specific form or insists upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstratively prejudice is shown. Point 4. In Bihan Kumar versus State of Haryana, it was reiterated the Article 22(1) is satisfied if the accused is made aware of the arrest ground in a substance, even if not conveyed in writing. Similarly, in Kasireddy Upendra Reddy versus State of Andhra Pradesh, it was observed that when arrest is made pursuant a warrant, reading out the warrant amounts to sufficient compliance. Both this post Pankaj Bansal decisions clarifies that written individualized grounds are not an inflexible requirement in all circumstances. Point 5. While Section 50 CRPC is mandatory, the consistent judicial approach has been to adopt a prejudice-oriented test when examining alleged prejudicial procedural lapses. The mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of a fair opportunity to defend. In the case, Lordship, what I understand, Lordship, demonstratively,
Like the Bhyan Kumar case.
Mm.
He was taken, then he was
Ah,
tied to the
right.
bed.
in that
and
case,
he
or
was
suppose
not-
demonstratively, suppose how you can say, explain it, Lordship, that Lordship, someone cannot defend himself because he did not know how I is.
He was tied to the hospital bed. He was
He was tied even in there. So, Lordship,
handcuffed to the hospital bed, I think.
demonstrably prejudice, he has to be demonstrably prejudiced that he could not engage anyone for defending himself. But now in all cases, Lordship, if you Lordship see, immediately after 2-3 days of his appearance, they engage their counsels, Lordship. In most of the cases, Lordship will find that on the same day,
Same day.
they used to engage. On when in almost all the orders, Lordship will find that Lordship, when the learned trial court asks them that whether you are you are going to appoint any engage, yes, my family will engage advocate.
Yes, yes.
So in some cases, legal aid counsel has been also engaged.
Engages.
So
The
they
trial court does in all the cases.
demonstrate prejudice, the denial of the High Court, however, relied heavily on the alleged procedural lapses as a determinative factor while overlooking the gravity of the offense under Section 302 IPC and the existence of a prima facie case. It noted inter alia that there was no mention in the remand orders about service of memo of ground of arrest, para 45. The arrest memos were allegedly
Done in many cases.
Mm.
And I have granted
Yes.
bail. Mm.
Memos were allegedly templated, based and not personalized, and eyewitnesses had not stated that they were present at the time of arrest or had signed the memos. Relying on Pankaj Bansal Union of India and Prabir Purkastra State and City, it concluded para 43, 49 to 50. 43, 49 to 50, that from 3/10/23 onwards, failure to serve detailed, written, and individualized grounds of arrest immediately after arrest was a violation entitled the accused to bail. 7. In the present case, the arrest memos and remand records clearly reflects that the respondents were aware of the reasons for their arrest, not ground, it is mentioned. Reasons for their arrest. They were legally represented from the outset and applied for bail shortly after arrest. Shortly, not the same day. Short means within 2, 3, or 4 days. Evidencing an immediate and informed understanding of the acquisitions. No material has been placed on record to establish that any prejudice was caused due to the alleged procedural lapses. In the absence of demonstrable prejudice, such as irregularity is at best a curable defect and cannot by itself warrant release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the search under Section 302 IPC and the existence of prima facie case. Its reliance on Pankaj Bansal and Prabir Purkayastha is misplaced, as those decisions turned on materially different facts and statutory context. In Pankaj Bansal or in Prabir Purkayastha, there was no, in Pankaj Bansal case, those ground of arrest was given, but in Prabir Purkayastha and Bihan Kumar, no any ground of arrest was furnished to them. And subsequently, they were demonstrably prejudiced because they could not engage their advocates also. Its reliance on Pankaj Bansal and Prabir Purkayastha is misplaced, as those decisions those decisions turned on materially different facts and statutory context. The approach adopted here is inconsistent with the settled principles that procedural lapses in furnishing grounds of arrest absent prejudice do not ipso facto render custody illegal or entitle the accused to bail.
Okay.
This is very much clear.
When was it decided?
It is decided on 14 August of this year. So many, thereafter, so many facts has been decided in all the cases. But we are regularly facing long incarceration. The search sheet has been filed. There are long list of witnesses. So it will take so many times. All these has been discussed for point-wise, Lordship.
All right. You want to say something?
Lordship, I'll go through this judgments, Lordship.
You'll place a submission later.
Submission, Lordship, clearly. So on date may be given, Lordship.
Okay.
On Tuesday, Lordship.
Hmm?
This Tuesday, Lordship.
Okay. Tuesday, this Tuesday. Not on Tuesday? Oh, okay. On 28th,
28th, Lordship.
Learned Counsel Mr. S.
Yes,
Hussain. Heard Learned Counsel Mr. S. Hussain, who has submitted 4 times to submit his reply on the citation on the decision placed by Learned Additional PP, Mr. P.S. Loper. Place the matter on 28 August. 28 August.
Oblast.
Or some other day, man.
Hmm?
While the briefing council as a file is not
Okay,
issued, some other day.
Learned Counsel Mr. N.K. Loper has submitted 4 times.
It will another case, Manish. It is.
List the matter on 29 August. 29 August.
Interim is there, man.
Interim lumber. Interim order আছে না?
Third, interim মানে কি?
10 September.
Well,
September last week or ফালে motion day হবো হ্যাঁ? Last week তো. Third week or তো হবো পাৰে নেকি motion day by any chance? Fourth week তো third week লৈকে date দিব পাৰিবা তাৰপিছত নোৱাৰিবা date
28.
man.
অলপ আগত দিওঁ কিন্তু বহুত ইণ্টাৰমেচিয়েট দেখিব
Diary আছে। CD is there, man.
20
Oh, CD.
CD is there, man.
Okay.
on last occasion we have taken that.
CD আছে যদি এসপ্তাহ বেছি দিবা। CD to be retained till then.
Interim order to continue.
Interim order shall continue.
I'm obliged.
May I please, Your Lordship?
Yes, yes.
In this case, Your Lordship, on the last occasion, the case diary has been called for, probably the case diary has been received. They basically, the FIR,
Oh, এইটো কাটিলো ভুলকে কাটিলো এইটো হেৰি তেওঁ submission দি দিলে ন? Okay. Just a moment.
yes, Lordship.
Submission দি দিলে হোৱাৰ কৰি দিলে নাই judgment মোক লাগিব মই তেওঁ judgment কিমান দিয়া ফাইল এটা আছে ন Yes.
Lordship, the petitioner is the assistant executive engineer. Now, what has happened, Lordship, is aware about the fact.
You have the CD, no?
Yes, this MLA development
So,
scheme,
develop what 20%. development.
Lordship, the MLA development schemes are there, and the pursuant to that MLA development scheme for infrastructure and other aspect of the matter, committee is being formed. So the petitioner was one of the member of the particular committee, Lordship. Now, what has happened after the completion of certain project, Lordship, the District Development Commissioner had lodged an FIR. Not an FIR, it's on communication, it is at page number 20, Lordship. Page number 20. The communication, it is to the officer in charge, Karimganj Police Station. A certain allegation that I am there, I am to inform you that Sri Sudeep Sarkar, who was entrusted as member secretary cum technical member of the construction committee, constituted by notification number such and such, and subsequently by this office order number such and such, dated such and such. Yes, Lordship. This is
The
not an
OC.
FIR, Lordship. This is a communication to the concerned to lodge an FIR against the present petitioner. Now, what has happened, I'm just referring to annexure 1, Lordship, kindly see page number 14. Page number 14. Yes, Lordship, this is an FIR, part of the FIR, Lordship. Page number 14. The IO, this is the report of the IO, the enquiry report. With due respect, I would like to
Just a
report.
moment, let me read.
Yes, Lordship. Page number 14, Lordship.
You are Sudeep Sarkar?
Yes, Lordship, and the petitioner Sudeep Sarkar, Lordship.
Any direction? I suppose. Yeah, simply as it happens.
Yes, what do you feel?
Also, this is the city lordship that he appeared before the IO and subsequently.
You are secretary?
Yes, Lordship. Pursuant to that, I appeared and I have recorded my statement also, Lordship.
But the IO has given some strong objection regarding his, and because he has not disclosed everything and he has failed to cooperate with the investigating officer. That is the IO not lordship. And in that case, also,
I have appeared and accordingly I have recorded my statement also, Lordship. And what is there in the allegation? Everything is that.
You are suspended, no?
Exactly,
No,
Lordship.
he-
I am under suspension.
no, suspension.
Yes, I am under suspension. I am under suspension. Even show cause notice has been issued against me. I have given reply to that. But the
For-
suspension order has not been revoked for more than 90 days. I am under suspension. For that also I am prejudiced, Lordship. So all these things are there, Lordship.
For clarifying those allegations, what the objection, Lordship may kindly.
Lordship, if the consideration is there for granting bail, in that way, Lordship, since I am not holding any official position at that point of time, and these are all documentary evidence. So I don't think I'm going to influence the investigation in any manner, Lordship.
What about the money? This
Lordship,
is almost 1 crore, 92
no, Lordship, the
lakhs.
thing is that I am the member of the construction committee, Lordship. My role is not there, Lordship. My job was being the assistant executive
No, but
engineer.
it was withdrawn to some.
No, Lordship, I have annexed that paper also, Lordship. That particular document, I have given a letter to the concerned deputy commissioner that much of work has been completed. But there is nothing like that. No contractor came before the deputy commissioner stating that they have.
I'll read it.
Yes, Lordship. That they have not received the amount, Lordship.